you. Today we're going to talk to you about defaults. Now, what is default? Default, it can apply in family law, civil law, in a way in criminal law as well, but it's called something different. A default is what we all understand is a case where you don't respond to what's been alleged. Like, for example, in divorce cases, you have 35 days to enter your answer or your counterclaim, and it could be in a restraining order case. It's just a term we use in the law that means that one side is going to proceed unopposed. And if you are in default, meaning you didn't file the requisite forms to make sure you can have a voice, your rights are limited in the sense of what you can present, mostly what you cannot present, what your activity is at a hearing, and what that looks like. So let me just give you a couple of examples of what that would look like. There's a lot of people who say, well, I don't have to go to court. Well, this is what happens. So here we go. So case in point one, you are you just got served with a divorce complaint. Who knows what's going on? You may be going through a lot right now, and you may not even want to deal with it. So you put it in your drawer. 36 days pass, and you might, you might not hear anything. You say, oh, it said 35 days. Oh, no one came to my door. No one knocked on my door. Nothing's going on. And then maybe another month passes. Then you get a notice. There's going to be a default hearing against you. What is that? What can you do? Well, a lot of people, they call a lawyer. They say, what can I do? Some people say, I'm just going to go to the hearing. And so you go to the hearing. You're at your own default hearing. And when it's you're watching the other person, your spouse, put on their case, and then you have all your stuff ready to go, and you go, okay, judge, I want to, and the judge will stop. Nope. You can't say anything. You have no right to bring in different evidences and present your case in chief as to what your claims need to be, because you're in default. So because you're procedurally in default, you can't do anything other than ask the other person questions. The judge might give you a closing statement, but you blew it there. So what do you do? So that goes with all cases, essentially. For restraining order cases, if you're not there, they'll proceed in default. So the person who's trying to get the restraining order will say their side without you being there. That can happen in civil cases. There's different rules and procedures for how you get into default. And, it's a good place to be, obviously. You can proceed unopposed. The downside of default, though, if you're going to be unopposed, is the time it takes to get to the goal line. And that's what's very frustrating with a lot of people. And I think a lot of judges are cognizant of that because you may have hired an attorney. Let's say you're the person looking for default now. You may have hired an attorney. You may have done everything yourself, and you did everything right. You followed all the forms. You served. You've paid your fees. And finally, you're here, and it's time to move on with your life. And at the last second, somebody is coming in and saying, Judge, stop the show, start over. And you may be going through a lot. You may be saying, this person just keeps on getting away with things over and over and over. But I'm telling you that if that person shows up and they file the proper paperwork, it's very common that defaults actually do get vacated. And that person will have a right to say what's going on and why they didn't answer. And, the family law, I always remind people, it's a court of law as well as equity. They're going to do what's fair. We're talking about not just money, we're talking about kids, we're talking about people's houses, things that you can't just replace, So anyway, that's defaults.